Information Blocking Overview, June 4, 2022. An educational presentation brought to you by the Hawaii Health Information Exchange. This material is presented for educational purposes only and is not intended to be a solicitation for services or legal advice. The purpose of this presentation is to provide an overview of the Information Blocking Rule, a part of the 21st Century Cures Act. It is not intended to be a review of the entire rule, and viewers should consult their organization's policies before acting on anything discussed in this presentation. The 21st Century Cures Act is intended to empower patients by giving them easier access to their health record in a modern health IT economy. The patient is at the center of the 21st Century Cures Act. Putting patients in charge of their health records is a key piece of patient control in healthcare, and patient control is at the center of HHS work toward a value-based healthcare system. The Act's goal is to provide patients with transparency into the cost and outcomes of their care, competitive options in getting medical care, modern smartphone apps to provide them convenient access to their records, an app economy that provides patients, physicians, hospitals, payers, and employers with innovation and choice. Information blocking is defined in the 21st Century Cures Act and in ONC's Information Blocking Final Rule. Information blocking means a practice that, except as required by law or covered by an exception, is likely to interfere with access, exchange or use of electronic health information. Or in plain English, do not refuse to share electronic health information unless you have a qualified reason. N. If conducted by a health information technology developer, health information network or health information exchange, such developer, network or exchange knows, or should know, that such practice is likely to interfere with, prevent, or materially discourage access, exchange, or use of electronic health information. In other words, if this applies to you, your direct action or inaction related to not sharing electronic health information could be a violation. Or, a practice that, if conducted by a healthcare provider, such provider knows that such practice is unreasonable and is likely to interfere with the access, exchange, or use of EHI. In other words, if this applies to you, be sure that your electronic health information sharing practices are reasonable and can be justified. The information blocking rule applies to entities that are called actors. Actors include healthcare providers, health information exchanges, developers of health information technology. This is different than HIPAA, which applies to covered entities and their business associates. Healthcare providers and health information exchanges are required to comply with both sets of regulations. Health information exchanges typically function as business associates under HIPAA. Health plans are required to comply with HIPAA as well as certain aspects of the 21st Century Cures Act, but not the Information Blocking Rule. The Cures Act defined a new term, Electronic Health Information, or EHI. Electronic Health Information, EHI, means electronic protected health information to the extent that it would be included in a designated record set, regardless of whether the group of records are used or maintained by or for a covered entity. But EHI shall not include 1. Psychotherapy notes, or 2. Information compiled in reasonable anticipation of, or for use in, a civil, criminal, or administrative action, or proceeding. This definition is consistent with the terms PHI and designated record set, defined under HIPAA. The Cures Act provides actors with time to demonstrate that they are exchanging all the necessary data elements by initially only requiring a limited set of data elements be shared. Prior to October 6, 2022, actors need to exchange data elements specified in the U.S. Core Date for Interoperability, USCDI, which is typically a subset of the data stored in an electronic health record system. After this date, actors must demonstrate that they are exchanging all data elements stored in the designated record sets they maintain. Under HIPAA, designated record sets, DRS, include medical records, billing records, payment and claims records, health plan enrollment records, case management records, as well as other records used, in whole or in part, by, or for, a covered entity to make decisions about individuals. The information blocking rule represents a paradigm shift related to the sharing of electronic health information. The Cures Act and its rules are designed to improve secure access to health information for patients and their healthcare providers to enhance the delivery of care. HIPAA has traditionally defined when it is appropriate to use and disclose PHI and PII. Rules are established to govern this sharing, and sanctions are in place for any inappropriate use of disclosure that may take place. In contrast, the Cures Act encourages more sharing of information by providing rules that block the flow of health information, unless this behavior is allowed as an exception. The Cures Act thus encourages sharing, while HIPAA restricts it. This is a paradigm shift affecting how actors manage PHI and PII, and creates the need to balance between sharing and restricting access. A provider must attest annually that it is not engaged in information blocking activities if it participates in Medicare and Medicaid promoting interoperability programs. Providers should develop and document policies that define the practices they consider to be reasonable. Actors do not have to share information in all circumstances. The Cures Act provides 8 types of exceptions that allow actors to deny requests to share information and not be out of compliance with the information blocking rule. The Preventing Harm exception. When a request is likely to result in harm to an individual, then access, exchange, or use of electronic health information may be denied under certain conditions. The actor must have a reasonable belief that harm will, or has occurred. Privacy exception. When a request is likely to result in non-compliance with regulations governing an individual's privacy, such as HIPAA privacy, then access, exchange, or use of electronic health information may be denied. Written policies must be in place, and the actor must be able to demonstrate that they are being applied in a consistent and non-discriminatory manner. A request may also be denied if an individual, that the data is about, has requested that their information not be shared. Security exception. When an actor's request is likely to result in a condition of non-compliance with HIPAA, as documented by written security policies, and/or will result in the ineffective protection of the confidentiality, integrity and availability of electronic health information, then access, exchange, or use of electronic health information may be denied. If the denial is based on security concerns not documented in a security policy, a written risk assessment must be performed. Infeasibility exception. An actor may deny a request to access, exchange, or use electronic health information due to infeasibility if it meets certain conditions. Requests to share or exchange information may be denied for specific reasons, including circumstances out of the actor's control, such as natural or human-made disaster. If the data requested cannot be segmented from data that may not be released due to compliance or legal restrictions, the type of electronic health information does not match the purpose for which it may be needed. The cost is not manageable. The actor doesn't have the financial or technical resources to comply. The request would result in a discriminatory practice, and the actor does not own or control the data that is being requested. Health IT performance exception. An actor may deny a request to access, exchange, or use electronic health information for performance reasons under certain circumstances. A denial can be based on temporary maintenance or improvement activities that make agreement with the request unfeasible, or because acceptance of the request will, or is, causing performance issues with the health information systems. Licensing exception. If a request interferes with the practice of licensing interoperability elements for electronic health information, then access, exchange, or use of electronic health information may be denied under certain conditions. To qualify for this exception, negotiations must be undertaken in good faith, must specify licensing conditions, must be non-discriminatory, and must not impede future development or performance. Fees exception. An actor's practice of charging fees, including fees that result in a reasonable profit margin, for accessing, exchanging, or using electronic health information are allowed as long as they are objective, reasonable, non-duplicative, and on some basis standard. Fees may not be prohibited by 45 CFR 164.524, c. 4, may not be charged to an individual for access to their own record, may not be to export data for the purposes of switching health IT systems, or to provide patients their electronic health information, and to export or convert data from an EHR technology if that was not agreed to in writing at the time the technology was acquired. Content and manner exception. An actor may limit the content that is accessed, transmitted, or exchanged, provided the actual content is consistent with requirements of the Act. An actor must fulfill a request in any manner requested, unless technically unable to do so, or they cannot reach agreeable terms with the requester to do so. Providers and HIEs should have policies in place that address the conditions under which an exception may be considered. Declining to share a designated record set for reasons that do not fall under one of these exceptions could make providers not compliant with the information blocking rule. Information blocking compliance starting steps. Identify the structure of your existing compliance program, and name an employee to lead your information blocking rule compliance. Review and update HIPAA and other policies to comply with the information blocking rule, including with respect to individual access rights. Perform a risk assessment to determine whether you are in compliance with the information blocking rule. Incorporate discussions on the information blocking into your compliance training. Speak to your EHR vendor about its information blocking rule compliance and to ensure that the vendor is not implementing health IT in non-standard ways. Address instances where your practice restricts access, exchange, or use of health information for HIPAA-permitted purposes, such as requiring written patient consent when sharing with another provider for treatment purposes. Review and address any practices that regularly delay patient laboratory results or diagnostic reports. Review your policy on sharing office notes and address the sharing of sensitive information contained in office notes. Update your National Plan and Provider Enumeration System, NPPES, record online to add your digital contact information. Consider sharing patient health information through the state's designated health information exchange as a way of demonstrating compliance. In conclusion, the 21st Century Cures Act is intended to empower patients by giving them easier access to their health record in a modern health IT economy. The patient is at the center of the 21st Century Cures Act. Putting patients in charge of their health records is a key piece of patient control in healthcare, and patient control is at the center of HHS work toward a value-based healthcare system. For more information on the information blocking rule and other aspects of the 21st Century Cures Act, visit the Office of the National Coordinator for Health Information Technology, ONC, at the URL shown on the screen. This is the end of the presentation. Thank you for your attendance. Please contact us at the Hawaii Health Information Exchange should you have any questions or suggestions for additional topics.